Welcome back to the Big Small Business Show, and welcome back to part 3 of a very legal Big Small Business Show episode today. And in studio with us, we've got Rui Marto. He's director of Marto Lafitte and Associates Incorporated. And we've been talking about shareholders agreements. We've been talking about employment contracts. And now I just want to talk about the most likely types of contracts we as small businesses will get involved in our first year or two in business.
So probably the very first one that people would deal with is the memorandum of incorporation of the company. So as you register a company, then in terms of the Companies Act, it's a compulsory agreement you entered into. In fact, when you register, unless you provide...
What is it? Is like a 2-page thing? Is it a standard template?
So the Companies Act deals with a short form MOI and a long form MOI. And the short form really, again, is the one that is registered when you automatically register without changing the MOI. And that really has the nuts and bolts of the company. So which are how many shares are issued, what is the percentage shareholding. And of course, now there's a new requirement which has been set this year, in terms of which at CIPC one has to now declare the beneficial ownership of the shareholding for the first time. So before you didn't disclose who the shareholders of the company were, now you do, and the deadline for that was October of this year. So the MOI is the first document, and again it sets out sort of the rules for shareholding, the shares, the voting, the meetings of shareholders, meetings of directors, and voting in respect of the directors as well.
If you haven't done it, if someone is watching this go, oh gosh, I didn't do that, can they retrospectively do it?
So they would have done it anyway, because when you advise, when either you yourself register with the CIPC, you automatically are registered with the MOI.
And what happens if now the things have changed?
So there are certain provisions that you cannot contract out of in respect of the MOI in terms of the Companies Act, and the certain things that are certain conditions that are alterable. So most of what you can still do is you could alter certain provisions within the legal framework and submit that to CIPC. So that would be really the first agreement that one would encounter. The second we've already discussed, which would really be the shareholders contract. So if you are in a shareholding, if you have more than one shareholder in a business, as we discussed, it's crucial then to have that shareholders agreement setting out. And just the difference between the MOI and the shareholders agreement is that the MOI is a public document. So that sits with CIPC. Anyone can go and see what a business's MOI is, whereas a shareholders agreement is an agreement between shareholders, which is private and not made publicly available. Okay. And that sets out other provisions, as we discussed earlier in this program. Then the third agreement that you're likely to do is you're looking for premises. So you're either going to buy or rent. And so you're likely to then go through a lease agreement. And in that regard, the tip I'd like to leave with the viewers is really to ensure that the premises are made for or can be used for the purposes for which you require them. All too often...
And that's like zoning.
Correct. So you want to make sure that the zoning, but also what I see a lot of the times is also electricity supply. So, especially with us with load shedding at the moment, is there a generator? Isn't there a generator? And especially if it's an industrial premises, sometimes you need 3-phase or you need specific requirements in respect of electricity. And if you haven't done the due diligence in terms of verifying that that is available, then you suddenly sign a 3 or 5-year agreement, which you cannot utilize. And there's an immediate dispute there. Again, it's important to do that homework. A lot of people don't read anymore. It's important to go through those lease agreements. And if you aren't able to know what those mean, then have an attorney check it for you prior to signing. The fourth one is your employment contract, which we've discussed as well, and early on in the segment. And then the fifth one really is whatever your core business agreement is. So if you're a franchise, that franchise contract. If you are selling goods, then you want to be able to have the supplier agreements in place to ensure that you've got the supply of whatever it is that you're dealing with. If you are dealing with clientele, you want to have your terms and conditions, whether it's on the website, whether it is in respect of your sale items. And you also want to be able to deal with, if you're offering credit, it's essential to have a credit agreement in place to navigate certain provisions of the National Credit Act.
Two very broad questions around contracting. Do I have to have the original? Or can I have a copy? Is that equally valid? Number one. And number two, what is this whole thing about signing in black?
Yes. So the signing in black is especially important relating to certain conveyancing documents, so where they get microfished.
Yeah.
And it's interesting that in Europe, for example, you have to sign in blue. And that's because photocopiers are so good these days, it's difficult to differentiate between a copy and the original. But in South Africa, for microfishing purposes, where the blue is sometimes too light, it has to be in black. So here it's
so
black.
That's the reason, okay.
In respect of originals or copies, what you want is to have evidence of the agreement. And so the original isn't essential. It's very few instances where you need the original document for a specific purpose, like a will, for example. There you need the original in order to hand to the master. If you don't have that, then it's a problem. It's that and the whole question of signing and initials, and do you need an initial every page, etc. So all you need in order for a contract to be valid from a signature point of view is for the signatures to appear on the last page. You don't need to necessarily sign every single page or initial every single page. You don't need to have it witnessed in order to validate the contract. The reason you want those things is from an evidentiary point of view. So the minute that the one party says, hold on, I didn't sign, or that's not my signature, or alternatively, hold on, when I signed, you now replace page 5 of the agreement. So to avoid those kind of disputes, it's always good to then initial every page to kind of confirm that those are the pages or those are the terms of that you've agreed to. And also the witnesses then assist with confirming that the person didn't sign under duress, that in fact they're the ones that did sign, to avoid all of that.
In terms of where do I keep all these contracts? Because, you've got a scanned copy electronically, and where do I keep them? Like, do I have to leave them with my lawyer, or what should I do with these contracts?
As long as it's safe. So we always recommend certainly having it on a digital copy, and then you keep it on the cloud so that there's, at least no fires that can come in, or thefts, or the agreements that are damaged. But I would keep the original in a safe place, and I would have a digital copy just as a backup, just in case.
Roy, that's all we've got time for today. Thank you so much for your insights. We're going to get you back to discuss other legal matters. I know it feels like quite a heavy topic for entrepreneurs, but I think it's so important. And I see so many businesses actually fall down because they have not implemented the advice that we've heard here today from Rui Marto, Director of Marto Lafitte Associates Incorporated. Well, that's it for today's show. Remember, if you think it, write it down and make it a reality.